Welcome back to News Talk here on News Channel 8 and our conversation this Thursday with WAMU 88.5 reporter Michael Pope. We started to talk about, and we want to go back to our conversation about the indictment of a Fairfax County police officer in the death of John Geer. He was shot and killed by police while he stood in the doorway of his Springfield home 2 years ago, a standoff between Mr. Geer and police ending in his death. An officer has now been charged. He is now fighting those charges.
Sure. This is an incident that happened back in August of 2013. So, we're talking about 2 years ago. So these charges are a long time coming. And, there was a long period of time that we didn't even know the name of the officer. Fairfax County has this reputation as being the police department and a police department that shields basic information. And so in this particular case, we're talking about the name of the officer was kept secret for more than a year after this happened. So now we're 2 years after the incident, and the county government had a $3 million settlement with the Geer family. That was back in April. So this sort of set the wheels in motion towards the second-degree murder charge that happened this week. And then it sort of you could get a sense of where things were going when the Fairfax County Police Department fired the officer back at the end of last month. And so that's when it became apparent that some kind of charge might be on the horizon. And in fact, that was the case, because this week the grand jury issued the indictment, second-degree murder, and so now that's the charges that he faces.
Fairfax County, the police in particular, came under considerable criticism for how they've handled this. I think the political leadership has been feeling the heat. But what reasoning did police give for not being more forthcoming about the basic details of Mr. Geer's death?
Well, one thing you often hear from police agencies is that this is under investigation, so we don't want to share information. Basically, that was sort of their mantra as all of this has gone on. This is a case that's under investigation. We're not going to tell you the name of the officer. We're not going to share basic facts. This is something, despite all the criticism and the talk about being more transparent, this is, this remains their modus operandi. If you think about the woman who died in the Fairfax County jail, the Fairfax County Police Department is still refusing to release the video of this incident. They have the video. They're shielding it from public view. They wrote a report, a very detailed report, of the actions of the sheriff's deputies. They're keeping that a secret as well. So they're giving talk about being more transparent, but we have yet to see them actually start releasing video and documents.
In the case of the what happened at the jail, we're talking about publicly produced footage of something that happened in a public place in the jail, and yet we're still in the dark as to what happened. Not an unusual thing necessarily, given that the sanctity or the need to make sure that a thorough and accurate and quality investigation, those things are paramount.
But the investigation is over. Another thing to think about here is the police department did an investigation of the sheriff's office. They have completed their investigation and handed it over to the prosecutor. The prosecutor may or may not end up bringing charges. Sort of that's his decision to make. But it's not like the police are still investigating this. Their investigation is finished.
I'm trying to think of a case that has unfolded in anything remotely like what we've seen here. Typically the criminal aspect, the criminal component of a case goes first, and if there's going to be a civil matter, that gets handled later. Here we've had almost, it seems like, an admission of guilt by the county, a multi-million-dollar civil settlement, and now the criminal case
very strange
is just now finding
the timeline here is just really messed up. For the $3 million settlement to happen back in April, and for us to get the second-degree murder charge in August, that's a very bizarre timeline. What's going on with this case here?
And think of the challenge facing the defense, the already considerable challenge facing the defense team, when the county has already written a big check to the survivors of the man who died, and now the defense team has to go in and argue some lack of culpability. This is a tall order, to be sure.
It's a tall order, and obviously it's weighing heavily on the mind of this officer who collapsed in the courtroom yesterday. So he made a brief court appearance, his first court appearance in this case, And after his lawyers were trying to get him released on $25,000 bail, the judge denied the bail, and shortly afterwards he collapsed in the courtroom. The bailiff had to clear out the courtroom. And so, this is a trial that is going to be very difficult, I think, for him.
What have Fairfax political leaders learned along the way? There have been withering editorials in the Washington Post criticizing their conduct. I think there were probably many in the county and many in the sort of pundit community thinking that the political leadership would step in and step up to close the gap left arguably by police in terms of how they've handled this matter, and yet that didn't happen. So what do you think Fairfax officials have learned from all this?
Well, in some ways, the elected leaders were sort of forced to intervene here because the police department was not giving the county prosecutor information in this case. And so the prosecutor ended up handing it over to federal officials as a result of not getting cooperation from the police department. That's when the Fairfax County Board of Supervisors got sort of intersected themselves in this story and created this commission, this ongoing commission that has yet to, before the end of the year, before the election actually, this commission is going to issue recommendations. So if the question is what have they learned, I would imagine this series of recommendations would be at the top of that. However, it's also worth pointing out that they haven't really changed their behavior yet, because in this case in the jail, we still don't have the video, we still don't have the report. If they had really learned the lesson, they might have started releasing more of this information.
Let's shift gears and talk about the situation in Richmond right now. Governor Terry McAuliffe came in with a big push, a big effort. I don't think his political opponents would deny that statement. He, like him or not, there was a certain amount of energy from the governor early on to try to establish relationships with the Republicans who control both the state Senate and the House of Delegates. Now they are butting heads over a couple of different issues. Let's talk first about the selection by the governor of a Fairfax County judge to sit on the state's highest court.
So this is a story that is sort of very complicated, on one level. On another level, it's just sort of raw politics and revenge, the politics of revenge. So the story here is there was a vacancy on the Supreme Court created by a justice who decided to retire earlier this year. His name is Leroy Millett. And Republicans believe Millett actually was acting kind of political by resigning after the General Assembly left town. So Republicans say typically what happens with these vacancies is the justice will let the General Assembly know, hey, I'm about to retire, start making plans to fill the vacancy. Republicans say Millett did not consult with them and waited till they left town, then resigned, allowing the governor to make a recess appointment of Judge Jane Roush. So Roush leaves the circuit court in Fairfax County and becomes a justice on the Supreme Court. She's currently a member of the Virginia Supreme Court. So meanwhile, lawmakers are called back to Richmond on a separate matter on the congressional maps. So because they're in session, they have the opportunity to consider this recess appointment. Actually, the fact that they gavelled into session sort of sets a clock into motion for that recess appointment to end. So 30 days after the session, gaveling into session, Roush's recess appointment actually will, expire. So they take this opportunity to unseat her. Basically, they say they have their own choice for the Supreme Court vacancy, and it's not Judge Roush, not Justice Roush. And so they essentially tried to unseat the sitting justice. This hasn't happened in more than 100 years. And so they were unable to do that, though, because their pick for this vacancy actually failed in the Senate by one vote. There was one Republican that crossed over to vote with the Democrats in a very sort of dramatic moment. A
gentleman who's retiring because he's sick of all the partisan headbutting.
Yeah, and he gave a very impassioned speech on the Senate floor that said, basically he disagreed with what the Republicans were trying to do to Justice Roush, who, it'd be one thing if she was unqualified or she did something wrong, and there was no argument about that. So he disagreed with what they were trying to do to her, and so decided to cross party lines and vote with the Democrats. He also, by the way, voted with the Democrats on this move to adjourn sine die, which ended the session.
So at this moment, the Senate is in recess and the House is claiming not to be in recess. I mean, this is the level it's reached,
Yes.
where the fundamentals, the basics, the are you in, are you out, this is a subject of dispute in Richmond among the state's highest leaders right now.
You're right. This is a level of disagreement and bitter partisan feuding that many people say is sort of Washington politics coming to Richmond. And they associate.
This is not the Virginia way, in other words.
Yeah, right. Well, I mean, actually, there has been a lot of talk about the Virginia way and is the Virginia way dead. I think if you look at what's going on here between McAuliffe and Republicans, you'll see they didn't treat Governor Kane this way. You know, Warner and Republicans did not have this kind of dramatic feuding.
Now, Governor McAuliffe consulted with one Fairfax lawmaker, one Republican Fairfax lawmaker, before appointing Judge Roush to the High Court, because, and we know this because that lawmaker was present at the announcement. But the broader beef is that he didn't consult more broadly with the GOP leadership. Is there something to that charge?
Well, again, this is, as you were saying about sort of facts are in dispute, you'll hear a different story from different people, right? So the Republicans will say they weren't consulted. The governor will say, well, I tried to call them and I got their voicemail. I mean, you know, after all this went down and the session was sort of over abruptly, the governor had a press conference and he said, what is this, Peyton Place? I mean, so there is a level of disagreement even now, right now, today. Is the General Assembly in session? That's an open question. We don't really know because the House is in session, the Senate is not in session. Does that mean
they're
the general
not meeting? They're just claiming to be, right? I mean, they're not actually there. They're just claiming that the way they left town was not adjourning but recessing.
They never formally ended the session on the House side.
But they're not actually in Richmond.
They're not in Richmond right now.
They're not saying, here we are, we're here.
But if the General Assembly is in session, the governor cannot make recess appointments. In fact, last year they did this. And they actually kept the General Assembly in session for the entire rest of the year at the end of 2014 into 2015 for the specific purpose of preventing the governor from making recess appointments.
We're over on time, but we have to talk briefly about redistricting, because the map is a significant piece of the puzzle. Anywhere you are at any time, it's been struck down, and there's no chance that these characters are going to be able to agree on a replacement, right? So this thing is headed to the courts too.
The deadline is September 1st. It's really clear the General Assembly is not going to take action by September 1st. That means that the three-judge panel in the Eastern District of Virginia will end up drawing the maps, and those maps will not be like the maps politicians would draw. You know, Republicans and Democrats sort of have this mutually beneficial arrangement where they create maps that benefit incumbents. Judges don't have that motivation. So the map that we're likely to get out of this three-judge panel will be very different than anything that could have come out of the General Assembly.
They could draw it much more toward keeping communities together. I mean, this is going to be a fascinating moment to see just how much of the existing, the status quo they throw out, and how they approach this whole business of map making, which could have a significant impact on Virginia politics broadly.
It sure could. Also, if you look at the incumbents, will they still live in their own districts? I mean, that's a question that we don't really know the answer to if the judges draw the maps.
Drama to come. Not that we have any shortage of drama in Richmond right now. Michael Pope, reporter for WAMU 88.5. Thanks as always for being with us. Good to have you here today.
Thank you.
We'll step aside. We're back with a check of the hour's top stories and much more right after this.